Hello, everybody. Good. As we're seeing the numbers go up, we just want to say welcome to everybody. Whilst we wait for more of us to join, let's get connected and check if the comment section are working. So if this is your first time joining us, please comment first on the chat box. And if you've attended this employment update before or any of our Employment Hero webinars, please comment returning. It would be really interesting to see how many of you have heard us before or any of our webinars. A lot of lovely first timers, so that's really, really great because we're in for a very packed day of a lot of the legislations within the Employment Rights Bill. And then I guess our next question, as we're waiting for a few more people for the next few minutes, what industry does your organization operate in? So we're just checking if how relatable a lot of the legislations here will be for you. Most of them we would see that it would be, but just trying to see how many would be working with a lot of like casual workers, 0-hour contract workers, for example. That's a lot of differences in there, so that's really, really great. Manufacturing, recruitment, that's great. Anyway, well, we won't keep you waiting. As I said, we've got plenty to cover for especially for those who are tuning in for the first time, which is many of you. So welcome to our UK Employment Updates webinar. I'm Jhecie de Chavez, a HR manager at Employment Hero. And with me today is Simon Obee, the head of HR advisory at Employment Hero. As you join, feel free to continue letting us know if it's your first time joining and if whichever industry you're from. Lovely to hear all the engagement here. So I'll just go over a couple of housekeeping rules and I'll likely mention these throughout the webinar as we have more people join. This session is being recorded and you will have a copy of the slides if you've signed up to this webinar. So don't worry if you're not able to keep up taking notes. No, you don't need to take notes at all. So this webinar is intended only to be a reporting of employment law updates, and you should not be considering this as professional advice to any specific situations you've got, but luckily Employment Hero has the HR advisory service for questions such as that. So if you have any questions during this webinar, you can use the Q&A function below. It's just next to the share or chat box, I believe, where Simon and I can see if we have any time to answer at the end. And any questions we aren't able to answer will be answered in an FAQ and sent to you a week after this webinar. Please don't use the chat function for questions as we may not be able to gather those. So we'll try to read as many comments and as questions as we go through, and Simon and I will switch that up. But for now, let's go through what we will be talking about on the latest updates of the Employment Rights Bill. So the Employment Rights Bill includes the proposed changes to areas of employment such as unfair dismissal, 0-hour contracts, and leave entitlements. But before we go through this hefty topic, we'd first like to remind you that in around 6 months' time, this is from the 6th of April 2026, I believe, the state pension age will gradually rise from 66 years old to 67. So employees nearing this age of 66 to 67 will become eligible to claim their state pension at different points within this range. So it will be on a bit of a sliding scale depending on their date of birth. So for example, if you have an employee who's 66 years old and 1 month, if born on the 6th of April 1960 and 67 years old for those born from the 6th of March, and don't worry, you don't have to remember these dates. We will pass you the slides after. From the 6th of March 1961, then they'll be able to claim from 67 years old. So The slightly longer wait may mean that some of your employees around this age will choose to work a little longer, but retirement remains the employee's decision. So you would not be able to force retirement on an employee. And so they can continue to work as long as they're capable of performing the work. There is an exception here where certain industries where compulsory retirement ages apply, or where there is an objective justification, such as, you know, what happens a lot in manufacturing or air transport, or police and fire, but you'll have to check for your specific industry what applies. And the next increase will not be until at least 2044, where that will go up again to 68 years old. Lovely time we're in with lots of medication. So with the state pension age, we just want to separate this from the normal minimum pension age, or the NMPA, or what would otherwise be known as the workplace pension age. Workplace pensions are still accessible from a minimum age of 55, rising to 57 in April 2028. Unless their specific pension scheme, so whatever you have set up and whatever they may have set up personally, separate to your current organization, that can be set at a later age, just as long as it's not below 55. Anyways, moving on to the Employment Rights Bill. So for unfair dismissal, actually, Simon, you go first for this one.
Yeah, thanks, Jesse, and hello, everyone. Yeah, before we jump into the detail of the Employment Rights Bill, just thought have a quick catch up on how far we've come and where we are now. So, as you might recall, the bill was introduced into Parliament back in October 2024, and since then it's been going back and forth between the Houses of Lords and the Houses of Commons. And a lot of amendments have been introduced to the bill along the way. So if maybe you heard a lot about the bill when it was first introduced, but you haven't been keeping up to date with what's happened to it since, any amendments to the bill which weren't there in the first draft, if you like, are highlighted in yellow in the slide, so you'll be able to see those quite easily. So in particular, what's happened recently is the bill went to the House of Lords, and the House of Lords introduced a whole load of changes to the bill. They put new things in, they took stuff out, and then the question was, well, when it goes back to the House of Commons, are they going to agree to it or not? And surprise, surprise, they rejected every single amendment that the House of Lords put in. So now the bill will go back to the House of Lords, and we'll be in the process of what's called ping pong, where the bill will go back and forth between the two houses until they can reach consensus, until they've agreed on the wording of the bill, and only then can it be passed. So the big question now is, well, will the House of Lords accept that their amendments have been rejected, or will they stand firm, and then there'll have to be some compromise on the part of the government? So it is still a bit up in the air what the final bill is going to look like. Even then, when the bill is passed and we have the final text, the way that the legislation has been set up is the government have reserved itself the rights to put a lot of the finer details in the new laws into separate regulations. So you'll have the bill, it'll become an act of Parliament, and then the government will issue kind of regulations which put the finer details in the new laws together, and they are currently consulting on the content of those regulations. So there is still quite a lot up in the air, as we shall see. So in terms of the timetable about when all this is going to come into effect, the government did publish a timetable of when they want the various provisions to come into force. Again, this is still up in the air, and depending on how long the ping-ponging will take, depends when this will all happen. The detail is on the slides. We won't go through all of them, but I've underlined a couple of the key provisions. So the government has said that the ban on harassment and discrimination complaints being covered in non-disclosure agreements. So we want to bring that into force as soon as possible. So that could happen perhaps on royal assent. In other words, when the bill is passed. So that could be, perhaps in the next couple of months. Then April 2026 is when they want to make the changes for statutory sick pay. The ban on fire and rehire, October 2026, and then not until 2027 will we expect to see the changes for unfair dismissal and the limitation on the use of 0 hours contracts and the obligation to provide notice of change or cancellation of shifts. So still a lot of time to prepare for many of those things, and of course when we get the final timetable we will let you know. But let's jump into the detail, and Jessie's going to talk about unfair dismissal.
Thanks, Simon. I've seen that some people have been struggling to hear. I hope all of that's been resolved now, but please flag it up in the comments if you're still not able to hear. And we will be providing a copy of the slides after this webinar. So onto the unfair dismissal. Currently, an employee needs to complete 2 years of continuous service to make an ordinary unfair dismissal claim. So this 2 years is the qualifying period. This legislation has enabled employers such as yourselves to terminate employees without following a full formal termination process. So this might be what's exactly written in your disciplinary policies. This includes communicating the reasons for terminating, as long as the termination was not discriminatory or relating to a statutory right, in which that would be a separate claim of automatic unfair dismissal. However, the government proposed to remove this 2-year qualifying period entirely and make ordinary unfair dismissal a day one right. So alongside this, a lighter touch dismissal process was also proposed to provide some support to employers. This lighter touch dismissal process is being suggested to last around 9 months from the start of employment, similar to a probation period. Then after this proposed period, employers would need to follow a full process to terminate or risk an unfair dismissal claim. And on the 16th of July, the House of Lords challenged this day one right and proposed a shortened qualifying period to 6 months instead. So this decision was because of the impact of the proposed changes on the already overloaded employment tribunal system, which at the moment is a 2-year wait to go all the way to tribunal, and the labour market, and the effect of that on small businesses being more scared, especially to hire new people, and that having a secondary effect on employees' unemployment in general. So this proposal would be was then rejected because the day one employment was the Labour Party's pre-election promise, as we had intended. The House of Commons was the latest to reject this so far. So then we go back to the House of Lords. And this was on the 15th of September. The next update we're hoping will be next month. So one of the reasons as well that they'd rejected the 6-month qualifying period is because they believe that it would weaken the Employment Rights Bill, and as quoted by the House of Commons, it is appropriate for protection from unfair dismissal to apply from the beginning of a person's employment. And as Simon mentioned, we will continue, the government will continue with the ping pong until there is a mutual agreement between both houses. Over to you, Simon, for the next update.
Thanks, Jessie. So moving on, another big change in the bill to the current law is banning or limiting the use of fire and rehire. So what is fire and rehire? Well, it is a process used by employers very much as a last resort, where they're faced with a situation where an employee won't agree to a variation of their contract, and the employer is really faced with no choice but to dismiss them or threaten to dismiss them to enable that change in their contract to be made and then rehire them on new terms. So it sometimes comes up when a business is in difficulty and it needs to reduce someone's pay or change their hours. The employee won't agree to that variation in their contract, and so there is fire and rehire, rehiring them on less favourable terms. A variation to that is fire and replace, where an employee is replaced in their role by another employee to do the same work, but on less favourable terms. Now, currently, neither of those things are specifically against the law. There's no specific law which prevents fire and rehire or fire and replace. The government has said that is unfair to employees. And so what the bill does is it makes it an automatic unfair dismissal to fire an employee for refusing to agree to a variation in their contract, or if the reason for dismissal is to enable the employer to rehire or replace the employee with another employee doing the same duties but on different terms. And there is one very limited exception where this will still be allowed. That is where the employer is in significant financial difficulty and needs to vary the employment contract in order to avoid bankruptcy. But it is a very high threshold, and anything less than that, it wouldn't be allowed. Now, that is what the bill originally said. There was lots of pushback from employer groups, and the government has since taken a slight step back from that original provision, and now it says that the ban on fire and rehire will only apply to the following contractual changes: pay reductions, changes to how pay is calculated, changes to pension entitlements, changes to working hours, changes to time off entitlements, and where fire and rehire is used to introduce a variation clause into the contract, which would allow the employer to change any of those things. Less significant changes, things which aren't listed on those dot points, fire and rehire will still be able to be used. The other thing which has been recently introduced into the bill is, as well as the restriction on firing and replacing someone with another employee to do the same tasks, the restriction will also apply to firing someone, then replacing them with an agency worker or a contractor or a freelancer to do the same role. So that is something that wasn't there in the bill originally. So I hope that makes sense. I'll keep going to the next topic, which is collective redundancies. So how does the law currently work? Well, employers proposing to make 20 or more redundancies at one establishment within a period of 90 days must collectively consult with the employees, in other words, meet with them, give them details of the proposed redundancies, consult with them, let them have their say on ways to avoid redundancies, etc., consider their points before they make any final decisions, involve any representatives they have, that sort of thing. They need to consult with them and they need to notify the Secretary of State. So at one establishment, what does that mean? Well, case law has clearly determined that at one establishment means an individual workplace. In other words, if you're a business with, say, 3 retail stores, you would need to have a proposal to make 20 redundancies, at least 20 redundancies at least one of those retail stores for the obligations to bite. If it was just 20 redundancies across the 3 stores, that wouldn't be sufficient. So that's how the law currently works. What does the bill change? Well, originally, the government wanted to make that obligation to consult and to notify the Secretary of State they wanted to change it so the 20 redundancies could be over the business as a whole. In our retail store example, as long as there was 20 redundancies across all the retail stores, that would be sufficient. There was a lot of pushback on that, so the government has stepped back and they have said that the 20 redundancies at one establishment rule will remain. What they have done, however, is given themselves the right to make regulations in the future, which will enable them to set other circumstances when the requirement to consult and notify will arise, even if there are less than 20 redundancies at one establishment. So, for example, they could introduce regulations which might say, even if there are less than 20 redundancies at one establishment, as long as there are, say, 50 redundancies in the business overall, or as long as there are at least 10% of the workforce overall being considered for redundancy, the obligation to collectively consult and notify the Secretary of State will apply. So again, we're going to have to see what is in those regulations. The government is consulting on that, and we shall see how that plays out in the future. Another change which is definitely happening is the penalty for failure to consult is doubling. So at the moment, if you fail to collectively consult when you were supposed to, you will have to pay up to 90 days pay per employee who should have been consulted. That penalty is jumping up to 180 days pay. So the fines for getting this wrong are going to be much more severe. Okay, let's keep going. So there's a lot to get through. And the next topic is 0 hours contracts and notification of shifts. So what's the law now? Well, as you probably know, it is perfectly possible to engage an employee or a worker on a 0 hours contract. A 0 hours contract is one where there is no minimum number of hours that the employee or worker has to be provided. And also there is no obligation on an employer to provide any period of notice of the shifts that someone needs to work who's on a contract like that, or no obligation to provide a specific period of notice if a shift is changing or being cancelled. So that's how the law currently works. Some big changes coming in this area. The first is that workers and employees who are on 0 hours contracts, or those who have a low number of guaranteed hours in their contracts, just how low will be set out in regulations, those workers will have a right to be offered a guaranteed minimum number of hours based on the hours they work over a particular reference period. The length of that reference period, again, is going to be set out in regulations, but it's likely to be around 12 weeks. So how that will work in practice is when an employer takes on a 0 hours worker or a worker on a low minimum number of hours, they will have to monitor the hours that they work over this reference period, around 12 weeks, we think. And then at the end of that period, they will have to offer the employee guaranteed hours based on the hours they worked. And then that period will continue and continue. If the employee ends up working more hours than they were guaranteed, then they will have to be guaranteed a new number of hours going forward. And that will continue perpetually until the employee's hours hit a certain threshold, after which they're not considered a low hours worker. What that threshold will be, again, it'll be in regulations. The employee doesn't have an obligation to accept that offer of guaranteed hours if they don't want to, but there is an obligation to on the employer to offer that. Now, one of the things you will probably be thinking if you're this is the first time you've looked at this is, well, how does that work for businesses such as seasonal businesses where they have the need for employees to work loads of hours at Christmas, but then a lesser number of hours for the rest of the year, or a business where they're very busy in the summer, but they need the employees to keep working but doing less number of hours at other times of the year. That's one really big challenge with this, and I'll come back to that in a second. So when the legislation went to the House of Lords, they wanted to dilute this. They wanted to say, rather than a right to be offered guaranteed hours, it should be a right for employees to request guaranteed hours. But if the employee doesn't request it, then the employer is under no obligation to provide those guaranteed hours. That was one big change they made. The House of Commons rejected that, and they said it's appropriate for workers who meet the qualifying criteria to receive a guaranteed hours offer without having to make a request for one. So that amendment was kicked into touch. Another amendment that the House of Lords introduced was to put an obligation on the government to consider seasonal workers when making regulations in this area. In other words, trying to encourage them to put an exception for seasonal workers when the regulations come in, which provide the detail about all of this. Again, the House of Commons said that was unnecessary. So it really leaves up in the air how these provisions are practically going to work for seasonal businesses. The one workaround that people are talking about is, instead of engaging someone on a long, ongoing 0 hours contract, it would be to engage someone on a short fixed term contract where they are guaranteed a set number of hours, but for a short period. After that, their employment ends. You then need to engage them on a separate fixed term contract in periods of work where the requirement for hours are less. But again, we're really going to have to see what the regulations look like and how this can work in a practical way for seasonal businesses. So stay in touch on that point. And obviously, it could well be that the House of Lords amendment is pushed through again, but we will have to see. The other thing which is changing or is likely to change is the obligation to provide reasonable notice of shifts to be worked and of changes or cancellation of shifts. So this is going to apply not only to 0 hours workers or those on a low number of guaranteed hours, but to any workers or employees who are engaged to work variable shift patterns. And there will be a financial penalty on employers for not providing reasonable notice of a shift or a change of shift or a cancellation of shift. So the million-dollar question, of course, is what is a insufficient notice? The House of Lords wanted to include a definition of short notice of 48 hours. The House of Commons rejected that. They said because that would preempt the consultation that they're having on this and limit the government's discretion. So it is still up in the air what an insufficient period of notice will be. We would expect that there is going to be carve-outs for changes or cancellation of shifts in emergencies, that sort of thing, but there will definitely be a period of time which is considered generally insufficient notice of a shift change. So yeah, again, waiting to see the detail on that one. Okay, ploughing on, flexible working. So how does the law currently work in this area? Well, as you probably know, employees have a right to request flexible working from day one of their employment, and they have to be consulted about that request. Employers don't have to agree to that request. They have an ability to reject a flexible working request on one or more of 8 specified business reasons. They're on the screen. I won't read them out, but things like it will cost the business extra money, or people can't be recruited to do the extra work in place of an employee going part-time, that kind of stuff. And the way that the law currently works is as long as the business genuinely believes that they have business grounds to reject the flexible working request, this can't really be challenged. What is changing in the Employment Rights Bill is to introduce a test of reasonableness. So it won't be enough that the employer genuinely believes they have a business ground to reject a flexible working request. An employment tribunal will be able to assess whether it was reasonable for them to refuse it. If they disagree, then the employer could be subject to a financial penalty and have to consider the request again. There will also be a new obligation to explain to the employee why it is reasonable to refuse the request, and there will be a power for the government to make regulations about how the procedure for consulting with employees about the request should work. Okay, we're going to move now into more family-friendly rights. So another change in the bill is to bring in a ban on dismissing women who are pregnant, on maternity leave, and during a 6-month return to work period after being on mat leave, except in specific circumstances. And those circumstances will be set out in regulations. It is not clear what those circumstances will be, but one would suspect it will include things like genuine redundancy. But if there aren't one of these specific circumstances don't exist, then employees will be protected during pregnancy and for 6 months after returning from maternity leave. Bereavement leave, I think that's passing back to you, Jhecie.
Yep, have a drink, Simon. Thanks for covering all of that. So we're going on to bereavement leave. So currently, employees are entitled to unpaid reasonable time off for dependents, and carers leave is a separate entitlement as well. There's also statutory parental bereavement leave, applicable only after the 24th week of pregnancy, though, or what would be defined as well as stillbirth. So employees aren't currently entitled to miscarriage leave, so that's 24 weeks before the 24th week of pregnancy, or pregnancy loss before then. So what is one of the proposed changes is for the bereavement leave to extend to the death of loved ones. This is quite a common leave entitlement already that employers give, but surprisingly is still not a statutory entitlement. So what is being proposed, to be clear, is 1 week of unpaid bereavement leave. So the purpose for this is, of course, to help employees be supported to cope and deal with the death of a family member. But in July, the House of Lords were in favor of this change and voted to even extend this unpaid bereavement leave to cases of pregnancy loss before the 24th week. The House of Commons did not comment on these suggestions in the September 15th update, but if this does proceed, more details on how this new unpaid bereavement leave would apply is expected to be shared in secondary legislation, so after the passing of the Employment Rights Bill, and may include a consultation when it comes to partners taking leave. And then in terms of parental leave, so today employees can only take parental leave after reaching 1 year with their employer. So this leave can then be used for up to 18 weeks in total and a max of 4 weeks per year until the child turns 18, and this is per child. So under the Employment Rights Bill, the government is proposing to remove the 1-year service requirement, like with many of the amendments. Parental leave would also become a day one right for employees if this is passed. Early in July, the government launched a formal review of the parental leave and pay system, which will examine how leave is shared between parents the adequacy of financial support and how the UK's approach compares internationally, such as especially within Europe. And this review is expected to last 18 months, so no changes on parental leave will likely be made by the start of 2026. But if there's any updates, you can tune in on our next year's updates. So with paternity leave, the bill also proposes to remove the current qualifying time period for statutory paternity leave to make this also a day one right. But as of now, employees must have worked for the same employer for at least 26 weeks by the 15th week before the baby is due. Again, that can be quite confusing, but should be outlined in your policies. And additionally, the government has proposed for the employees to be able to take paternity leave after shared parental leave. So this proposed change hopes to provide families with greater flexibility. But paternity pay will be part of that wider parental leave review. So it will also be unlikely that any paternity leave or pay entitlements will, any changes to those will take effect by the start of 2026. Over to you, Simon, for the next round of updates.
Thanks, Jesse. I was behind you on a slide there, but we're all caught up. Okay, so another change in the bill relates to gender pay gap and menopause support reporting. So how the law currently operates is employers with 250 or more employees already have to report on and publish gender pay gap information. That is, the difference between what men and women are paid in their organization. They already have to report and publish that. What is changing is for those employers with 250 or more employees, as well as reporting and publishing on those statistics, they will have to publish action plans addressing how they are combating gender pay gaps, so what steps they are taking in their organization to deal with a gender pay gap. And they will also have to report and publish the support they provide employees going through the menopause. Now, there was originally a proposal that these employers should also publish action plans setting out the support they provide for employees dealing with menstrual health issues, but that was rejected, so that is not currently on the legislation table, as it were. Okay, another change in the bill relates to discrimination and sexual harassment. As you will no doubt be aware, employers are currently under an obligation to take reasonable steps to prevent sexual harassment in the workplace. Employers can be liable for sexual harassment that occurs in the workplace, as can the perpetrators be found liable too. What is changing is the test for defending a sexual harassment case as an employer is going to be tougher. Employers will be under an obligation not to take reasonable steps to prevent sexual harassment, but to take all reasonable steps to prevent sexual harassment. So the addition of the word all before reasonable steps. What that will mean in practice, we're going to have to wait to see, but the short point is that it is going to be a greater onus on employers to deal with sexual harassment in the workplace. Another thing that the legislation really clarifies in terms of sexual harassment is that the duty to prevent sexual harassment also applies to preventing third-party sexual harassment. In other words, harassment of your employees by customers, by members of the public, etc. So it's going to clarify that that is part of your duties, and this won't just apply to third-party sexual harassment, but to third-party harassment on any of the usual protected characteristics, so age, disability, pregnancy, religion, gender, etc. So that duty to think about and try and prevent third-party sexual harassment is going to be something quite new for a lot of employers. It is something that people struggle with conceptually. How can we control the actions of third parties? But it'll be things like, can you make sure that your employees aren't working alone, so that they've always got someone to report issues to, or that they're not forced into physical environments where they're at risk of third-party harassment? Have you got adequate CCTV? Is there abilities for employees to raise alarms? Have you mounted a poster or some other campaign telling third parties that you don't accept harassment of your staff? It'll all be those sorts of things, those sorts of steps that you'll have to think about, particularly if you're in an environment like hospitality or something where people are going to be in close physical contact with members of the public. So that is something new that businesses are going to have to think about. The other new change in this area is the government has approved an amendment to the bill which bans non-disclosure agreements which relate to harassment or discrimination matters. In other words, going forward, it's not going to be possible to have a settlement agreement or a clause in a contract or a non-disclosure agreement which prevents an employee from discussing a sexual harassment or discrimination or any kind of harassment complaint or claim. That is obviously, that we don't have that in the law at the moment, so that's going to be a big change. Regulations are going to set out exceptions to those positions. It's not clear what's going to be included in those exceptions, but one of the suggestions is that where the employee themselves has requested for harassment and discrimination to be covered in the NDA, as opposed to this coming from the employer, that will still be allowed. So again, more details to come on that. But if you were using template confidentiality agreements and template settlement agreements, you're going to have to be very careful that those don't offend the law when this change happens. And as I said at the start, this is one of the areas where the government has committed to bringing in this provision as soon as possible. So that could be with us, possibly even in the next couple of months. Okay, statutory sick pay. I think that's you, Jhecie.
I believe that's still you.
Oh, is that still me? All right. Okay. Statutory sick pay. What is the law now? Well, as you know, currently employees need to be off sick for 3 days before they get statutory sick pay. In other words, it is paid from day 4. And there is a lower earnings threshold that employees need to earn before they can be entitled, which is currently £125 per week. The Employment Rights Bill makes statutory sick pay a day 1 right. In other words, it will be paid from day 1 of sickness. And it also changes the rules around lower earnings. It abolishes the lower earnings threshold. So employees, no matter what they earn, can be entitled to SSP, but there will be a reduced rate for low earners. What that rate wasn't initially clear in the bill, but the government amended it to say that low earners will get 80% of their usual pay. Obviously, this is a big change for employers because it is employers who fund statutory sick pay. It's not one of these things that is funded by the government. So you're going to have to factor that into your wage cost budgeting and really going forward, more than ever, it's going to be important to try and think about employee well-being, making sure people aren't overworked and stressed, and that you're not contributing to employees taking sick leave, because it is obviously, there's going to be a financial consequence of that. Okay, we will finish off with a few other quick fire amendments to the bill, which weren't in there originally. So the first is tribunal claim time limits. The current time limit that employees have to bring a claim in the employment tribunal is, of course, 3 months. That will increase to 6 months. That is invariably going to lead to more claims from employees. So it will be more important than ever that you follow robust performance management, misconduct, disciplinary procedures, particularly anything involving termination of employment. You'll need to make sure that you are really following best practices there, because the likelihood of getting a claim is going to increase. I think there's no debate about that. A couple of other amendments which you might have heard about recently, which were introduced by the House of Lords but have been rejected by the House of Commons, but we'll have to see what happens next. The House of Lords wanted to have a new right to time off work for special constables. The House of Commons disagreed that that was necessary, but they did commit to including in the legislation an obligation to review the existing law regarding time off for public duties. So we'll have to see what happens with that. The House of Lords wanted to put in greater protections for whistleblowers. So, for example, protecting whistleblowers from unfair dismissal, and putting a duty on employers with 50 or more employees to investigate a whistleblowing complaint if they received one, a specific duty to do that. That was rejected. The government said it's inappropriate to make changes in the manner proposed to the protections for workers who make protected disclosures and to the duties of employers in relation to such disclosures. Protected disclosure obviously being the official word for a whistleblowing complaint. So those are two things that were rejected. And then the last thing, which you also might have heard about, got some a lot of media coverage, the right to be accompanied at a grievance or a disciplinary hearing. The House of Lords wanted to extend that right, so employees had a right to be accompanied by a certified professional, e.g. a lawyer or other professional. The current law, of course, is that they just have a right to be accompanied in grievances or disciplinary hearings by a work colleague or a trade union representative. The House of Commons rejected that, and they said it would likely lead to an increase in the cost, complexity, and length of such hearings if employees had a right to be represented by lawyers or other professionals. So again, that is out of the bill as currently stands. So I think that was everything we were going to cover in the main part of the presentation. Jhecie, can I hand back to you just to have a quick word on HR advisory?
Yeah, thank you. So good news, at least we've got time for some questions, so you can stay, see if your questions get answered. And also I'd like to highlight that we've got a redundancy webinar coming up next month, which I believe the register link has already come out or will be sent out afterwards. And as we near the end of this webinar, we just want to remind you that at Employment Hero, HR advisors such as myself partner with you to reach a fully informed decision that is best for your business, but remains compliant with employment law. So you can scan, I believe there's a QR code after that, If you want to find out more, I think it's the next page, Simon. So HR advisory is not just for employers who don't have a HR person. We often serve as an additional support, reviewer or sense checker available to anyone, including HR directors. With unlimited advice, regular legislation updates, HR document reviews, and template help. So that's creation and reviewing. You can count on our expert HR advisors, including, so it looks like we've got quite a lot of questions. So let's try and do some Spitfire questions and see what we've got here. But if we don't have time, please do keep sending in your questions and we'll answer them after the webinar. So let's go with so in terms of the qualifying period and the probation periods, would anything stop employers from introducing and enforcing long probation periods? And so would probation periods be protected under this bill? So I can answer
is
a bit
that a
about
question for me?
You want to follow it? So
Yeah.
in terms of would anything stop employers from introducing and enforcing long probation periods? There isn't anything on the legislation that specifically forbids this, but always bear in mind in terms of the length of probation periods, if it ever you were to get a claim on this, it would be reviewed if the probation period length was reasonable in terms of assessing. And in terms of that 9-month probation period, it's not final yet. It may be a statutory, but again, with the law, it's for such things like these, it's focused on the minimum rather than setting a maximum probation period. Our probation period is protected under this bill. So a bit similar like with the law now, having a probation period at the moment does not mean that you can't or you can make a claim, because there is that 2-year qualifying period, even if the employee's passed probation. So what will happen if it becomes a day one employment right to make an ordinary unfair dismissal claim is the employee could make a claim even during their probation period. But what we don't know for final yet is if the probation period of that 9 months will allow employers to follow a shorter form or lighter touch dismissal process. Hopefully that answers that question. Do you have anything else to add on that, Simon?
Yeah, I mean, I think it's the kind of bottom line is you can't use a probationary period that you set to get round the unfair dismissal provisions. So you can set your probationary period at any length you want. You can do that now, and you'll be able to do that if they make unfair dismissal a day one right. But the reality is it won't protect you if the law changes so that employees can claim unfair dismissal from day one, and you've set your probationary period at 3 months. They're going to have the right to claim unfair dismissal from the first day of their employment. So setting your probationary period at whatever you set isn't going to give you an ability to safely terminate their employment if they've got unfair dismissal rights. As Jesse says, what the government are suggesting might happen is that you'll have a day one right for unfair dismissal, but in the first 9 months, the employer can follow a kind of light touch dismissal procedure, which will probably just involve meeting with the employee or having a very kind of basic performance management process or something like that. So if that's how it plays out, you would want to line up your probationary period with that the end of that light touch period. But the short answer is it's not going to stop you setting probation periods as you want. But remember, if they've got unfair dismissal rights, the fact that you've got a probationary period isn't really going to protect you. You can't say a dismissal is fair just because I dismiss someone within probationary. You'll be expected to follow whatever process the law sets. So I hope that makes some sense.
Thanks,
Was there
Simon.
another
So
question?
it's plenty, I can tell you that. So if someone is on a fixed term contract with good performance and replaced rather than their fixed term contract being extended, does their employment rights bill protect them? I believe this is already in place even without the employment rights bill.
Yeah, so read it again, Jesse.
So if someone is on a fixed term contract with good performance, can they be replaced rather than being extended for the same role, I'm guessing? And what would the employment rights bill protect them from?
Yeah, I don't think there's anything in the bill which changes the law around that. I mean, if there's a genuine reason to use a fixed term contract and it's because it's for a particular project or there's a specific need to use the fixed term contract, then an employee shouldn't be able to challenge um, the fact that the fixed term contract isn't extended unless it's for like discriminatory reason or something like that. Where this becomes a problem is if there's not a genuine reason to use a fixed term contract and it's just being used for convenience, then you get yourself into issues of well, is that a dismissal when it's not renewed? But if it's being used for a genuine purpose, I don't know, it's for a particular time limited project or you've got funding for a particular period, then you should be able to rely on the terms of a contract that it ends and then engage anyone you wish to. But there's nothing in the bill that changes that I can think of. Do you agree with that, Jesse?
Yeah, agree. Okay, so another one is are there, just going back to all of the updates, which changes are would, if passed, would be likely to take place on the April 2026? I believe so far you've mentioned the statutory sick pay.
Yeah, so the ones that will come in immediately are likely to be the stuff about non-disclosure agreements and banning on them covering harassment and discrimination, and also provisions dealing with trade unions and strikes, which we haven't covered. But it's April 2026 where we'll see increases in penalties for breaching collective redundancy, day one rights to paternity leave and unpaid parental leave, the establishment of the Fair Work Agency, which we didn't talk about. There's a new government body tasked for enforcing employment rights, and then statutory sick pay being a day one right and a removal of the lower earnings for eligibility for SSP. So those are the April 2026 ones, and then October 2026 and into 2027 the remaining provisions.
Thank you. And then when it comes to the gender pay gap, 250 employees in the UK, or can that number affect across other EU locations?
Jesse, do you know the answer to that off the top of your head? I'm afraid
Yes.
I don't.
I believe it's in the
Yeah, I'm not sure. Yeah, I think it's what did you say? You think it's in the EU?
I believe it's in the UK only because a lot of the legislations would usually only apply in the UK, but don't quote me on that.
Yeah,
Uh,
I think you're right. But let's look that one up and
One of the
we'll
answers we will definitely delve into. So I guess the last question that I'll take for now is that there's there was a question if we also provide payroll guidance in HR advisory. So we do provide some limited advice on payroll, but we also have, as part of the Employment Unlimited package, the managed payroll service, or payroll help there, which could come as part of the full HR service. Yeah, we've run out of time, sadly, but we have received a lot of your questions. We've tried to, we're sorry that there seems to be an issue with the Q&A, but we're trying to capture as many on the comments before we leave to see if we can answer as much as possible. The recording and the slides will be sent to you after the webinar, and the Q&As just a little bit later to make sure we can answer everything. But you can also reach out to us on LinkedIn or your contact at Employment Hero. So there we conclude today's webinar on the latest updates on the Employment Rights Bill. And thank you, Simon, and thank you everyone for joining in. Have a great rest of your day.
Thanks, everyone.